Good evening, Captain Retired Matt Edwards with the next Facebook Live broadcast for my Observation Post Weekly Report. Today is the 18th of May, 2023. Now, continuing on with last week's points, number 262 in my file that I keep adding to, that it's in my files part of my Observation Post group. Interpretation Act Section 12. Laws are to be interpreted broadly and generously so as to achieve their purpose. Income Tax Act Section 61F and periodic, the word periodic, is a good example of that, how that is broken. What I'm referring to is that there is the Income Tax Bulletin 428, in which Canada Revenue Agency puts its legal position on paper so people know what its position is if you want to challenge it. So Canada Revenue Agency is part of the executive branch of government. Legislators make laws. The executive enforce the laws that members of Parliament create, that we elect. And the judges, the judiciary, they judge, interpret, make decisions about things. So you have three different branches of government, and CRA wants to overrule the members of Parliament that we elected, because they put the word periodic in the Income Tax Act. Now, periodic is a word that means you get regular, payments from now and then. It's not a one-time payment. Now, for example, damages are always paid as a one-time payment. So after the Dennis Manuge class action, for example, the class were paid money, damages, to settle a legal dispute. They didn't get paid income, despite the fact that it was taxed under Income Tax Act Section 61F. Even if it was income, it wasn't paid periodically. So the class should not have had to pay any taxes on the receipt of a lump sum. Now, this also came up in a case in 2005, C. Prelis, Supreme Court of Canada, 2005. Now, I'm sure CRA would point to that about the fact that the court has sustained, their opinion that our lawmakers don't matter. But you see, the judges, they didn't get elected to make law. The executive branch didn't get elected to make law. So basically, in this example I'm giving, they're breaking Interpretation Act Section 12. Because Interpretation Act Section 12 says you had to read the words in an act in a broad and liberal manner so as to achieve the purpose of the act. Now, you have to ask yourself, what is the purpose of the Income Tax Act? Well, it has two purposes that I know of. The first is to raise revenue for the government. Everybody should know that. The second, however, is to redistribute wealth to selected groups. So, for example, they had the age credit that gives less taxes, more credits for people who are old. You have the disability tax credit, so that gives people who are disabled more money because they had to pay less taxes. Well, they could have left long-term disability insurance alone, because from 1917 to 1971, it was not taxed, period. No insurance can be taxed because it's not income. But in 1971, following the 1966 Royal Commission, the Carter Royal Commission on Taxation, he said that every financial transaction in Canada should be taxed. Now, that would include life insurance, that would include long-term disability insurance, but the government did not follow the recommendations of the Carter Royal Commission. But they did choose to implement one part, and they started to tax long-term disability. But they didn't tax it wholesale. They decided to tax it only in two circumstances. One, the payment has to be periodic. That's the very thing that CRA and the government are ignoring for people who get a lump sum. And it often happens, like when I got my son life back in 2009, they hadn't paid me from January to August. So the first payment I got was a lump sum. In my Manuge Service Income Support Insurance Plan, policy 901102, by the time they finally approved me and paid me, it was almost due to expire at 24 months. That was a lump sum. It shouldn't have been taxed. But the government wants to have it as if the word periodic wasn't put into the Income Tax Act. Now, I'm sure I could come up with other examples, but when I was writing that, and I want to keep this short tonight, that was the clearest example, and I'm always harping on that because it's such a clear example. Because that case I mentioned, Cia Praelis, it wasn't like that case was referred to the courts for the court to determine an interpretation of the word periodic. Because had it done so, it would have had to refer to the Interpretation Act, and it would have had to give it broad and generous meaning so as to achieve the purpose of redistributing the people's taxes. It isn't about the government getting as much taxes as it can. It's supposed to be a fair way, you know, the law is supposed to be fair. Okay, number 262, another tax point. The Tax Court of Canada, the CC actually, my mistake. What is their mandate? Can they overrule laws made by legislators? And can they interpret the Constitution and Charter? Now, these are questions I put there because I don't know the answer. But I do know that when they first created the Tax Court of Canada in the 1990s, I have it in the Hansard. I don't have it right at hand, but I know from reading it. A member of the opposition opposed the creation of a branch of the executive being asked to judge tax cases because they said it was a breach of the the procedural rights, like criminal and, you know, civil stuff about being treated fairly. When you have a court case, you're supposed to have an independent judge, for example. Now, if you have a branch of the government, which is the executive, and you have a Canada Revenue Agency tax assessment, that's branch part of the executive, and then you have a case that you want to oppose CRA on something like the word periodic. Well, can the Tax Court of Canada, which was created by Parliament, choose to interpret the words that are put there by our elected members of Parliament? I don't think they have the right to do so because of the fact that they were a creation of Parliament. That's one example. But the thing is that when I was having my tax appeal, okay, I put in a tax appeal on my taxes on long-term disability and stuff, and I went through about 2 hours or 3 hours of talking to the appeals officer about different things. I said, first of all, the Income Tax Act is designed to tax an increase in your wealth. And insurance is designed to replace what you lost. Good point, she said. So after 2 or 3 hours of good points and her agreeing with everything I said, she said, your appeal is denied. Now, when I'm getting feedback from someone I'm talking to, and they tell me I'm right all along, at the end of the conversation, if they have the power to do something about what I'm asking them, I expect them to agree and say, well, I'm going to wipe out the taxes on this long-term disability because you made some really good points. But instead of that, she said, well, I have to obey the law. Well, they aren't. The law says periodic. Now, the other condition, besides being periodic, is that the payment has to be, the premium for the insurance has to have a contribution by the employer. Now, as usual, I can point out that this is a flawed notion. The 1969 Parry versus Cleaver case had a person who was injured by another person. Now, when the insurance argued that the disability pension should be taken into account to reduce the damages because the person hadn't paid any money for the pension, so therefore they wanted to save on the tax damages by saying that, you know, because they didn't pay for it, therefore it should be taken into account. The judge said, words to the effect that, I'm sorry, why should the person who was injured suffer because he didn't pay for it with cash when his service has value, and the payments to the pension were made by the employer, but they were made on his behalf. So therefore, they were his payments. Now, think about that for the insurances I'm talking about. The Service Income Support Insurance Plan is allegedly paid 85% by the government and 15% by the Canadian Forces member. However, the 15% that was earned by, taken off of the check by the government, was earned by the Canadian Forces member, and the 85% that was paid, allegedly, by the government is also earned by the Canadian Forces member. Nothing in life is free. So 85 and 15 are 100%. Now, the Income Tax Act says when you pay 100% of the premium, you don't have to pay any taxes if you get long-term disability insurance and you bought it yourself. Now, backing up what I say, there was a case about group insurance in Raytch, Supreme Court of Canada in 1990, and the Supreme Court judges said that why should, because of the principles of insurance, private insurance be treated any differently than, well, group insurance be treated any differently than private insurance. After all, they're both insurances. So, because there was no insurance that was allowed to be deducted from damages under the private insurance exception rule, if it's group insurance versus private insurance, it doesn't matter. That's what they said. Now, I think I've beaten that one to death. Let me try the next one. Former Minister of National Defense Peter McKay and Reserve Force Workers' Compensation. Now, I think I've traced it back to 2009 or 2011. Around that time, the government, the federal government, decided that a reservist wasn't really a soldier. They were more like a civilian worker, and they could apply for workers' compensation instead of going to Veterans Affairs Canada. Now, that's a slap in the face. Even though some people, some veterans might decide and would rather deal with the provincial system than Veterans Affairs Canada, according to the rules, you're not supposed to. Okay? When you have a workers' compensation type system, you're supposed to have a single administrator. You're not supposed to be able to choose which one you want, because that would violate the merit principles of workers' compensation. Now, that, by itself is not the only point, of course. I believe the reason why they said this is that in the Government Employee Compensation Act, it says that a regular force member and an RCMP member, it cannot get government employee compensation. Now, that is the federal version of workers' compensation. So what happens is if a federal person, federal people are prisoners, natives, soldiers, used to be the RCMP, but not anymore. So federal persons, if they get hurt, and public servants, of course, if they get hurt on the job, then they have to make a provincial application like every other person. Then, if they get approved, they get paid normally, and the provincial workers' compensation then bills the federal government and gets reimbursed. Now, this is a violation of the workers' compensation principles too, as far as I'm concerned, because it's supposed to be an insurance, and you pay insurance ahead of time. So you pay premiums in workers' compensation. The employer has to pay all of the premium, and it's paid ahead of time. So the federal government doesn't pay premiums ahead of time. Neither does the provincial governments as well. They, because they're the government, they pick up the tab after. Now, it might say, some people might say, who cares? Well, if you're not going to be part of the system, how can you claim, that you're part of the system? I mean, they piggybacked onto the provincial workers' compensation system with the Government Employee Compensation Act. Anyway, I got a bit digressed because I was trying to point out that just because somebody looked at this legally, and I'll go back to Interpretation Act Section 12, So they looked at this in a narrow and technical viewpoint, and they said, aha, the previous legislators didn't cite a reserve force Canadian Forces member. So therefore, there's a loophole, and they can apply. Well, that's not given it the liberal and generous interpretation. That's a narrow and technical interpretation, and they were in control of the words at the time. So the thing is that every Canadian Forces member, all military members, should be treated the same. I think you'd agree. So in a perfect world, everybody should make the claim to Veterans Affairs Canada, and they shouldn't be treated any differently just because they're a reservist. However, you know, Veterans Affairs Canada is not the best. They don't have any reservists hardly at all. Back when they were looking at something in 2013, I think, or 2015, the Office of the Veterans Ombudsman mentioned that there was only 2.5% of veterans were supposedly reservists. And what they did was they extrapolated that from who was getting the minimum earnings loss benefit. I don't think that's a good way to extrapolate that, but it does prove, because it's less than 4%, which is the threshold for materiality. In statistics, if something is less than 4%, it's the same as 0. Okay? So in terms of pay, for example, if you move from one pay rank to another pay rank and the difference is more than 4%, it's a promotion. If you get demoted, if you get moved from one job to another job and it's less and it's more than 4% in the maximum pay, well, that's a demotion. So the statistically significant point I'm trying to say is just as well to say there are no reservists in the Veterans Affairs system if it's 2.5%. If the Office of the Veterans Ombudsman is correct, then it's just as well to say it's a regular force, former regular force Canadian Force member institution. Now, moving on to 265. Were the law costs for the Manuge case claimed on taxes? Now, I think they were, but I can't remember. When you take your employer to court over income, you're allowed to claim your legal costs. Okay? So if it takes money to go to court and enforce a claim, then when you do your taxes up, you reduce your claim for income by the amount of legal costs it took to get your money. Now, there was a pretty big kerfuffle about the law costs for the Manuge case. Okay, if I recall, it was 30% of the gross if it was settled without an appeal, and 35% of the gross if it went to appeal, and McKinnis Cooper would get that much money from every person in the class. But former Minister of National Defense Peter McKay, again, answered a question from a fellow Conservative in the House of Commons, and they said, aren't these costs that the veterans, the disabled veterans that are taking the government to court under the Manuge class action, aren't they getting shafted by the lawyers who are charging $13,000 an hour? And Minister McKay spoke up, and he agreed with his fellow Conservative. Now, the thing is they should not have stuck their nose into what is basically a contract between McKinnis Cooper and Dennis Manuge. Okay? The government should not send a chilling message to society by sticking its nose into something that it could have avoided by not screwing over the veterans. If they had not deducted the value of the pension from the Service Income Support Insurance Plan, then Dennis Manuge would never have to take the government to court. If he hadn't to take the government to court, then he wouldn't have had to pay, he and the class wouldn't have had to pay 30 or 35% of the gross. So for the government to say that it was exorbitant, these charges, is the heights of hypocrisy. Okay? They should never have brought it up, and then it got knocked down to 8%, I believe. Now, it still came out to a lot of money. I believe one veteran I looked at had $50,000 in legal costs. Now, as a curiosity, because I'm a curious person, I did up that person's taxes with and without the legal costs. Had he paid the legal costs, he would have gotten a tax refund. But because they had lower income legal costs charged by the government, like government action, government interference, like it could be tortious interference with a contract, that's a tort. He ended up having to put $15,000 more with what they deducted from his payment, because they charged him $160,000 in taxes and $145,000 in taxable income. Now, I hope you are listening, because that is atrocious. Interpretation Act, Section 12, certainly does not support that kind of conclusion, that you would harm the veteran by having their disability pension. Now, this veteran was blown up in Kosovo. He ran over 2 stacked anti-tank mines and lost 2 legs below the knee. Now, Tom Anderson, by the way, Corporal Retired Tom Anderson, got blown up by the enemy. He lost his career because of it. He lost his legs because of it. And then, because he got a Pension Act pension, they deducted that from his service income support insurance plan, and he ended up having to take the government to court along with the other veterans. The law costs might have been taken off in other people's case. I don't know. Maybe people forgot about it. But it could be an issue. Now, whether all the veterans had the same situation as Tom, I don't know, because I only examined his case, and I punched in the figures, and the only reason he was going to get a tax refund was because they deducted so much money from his settlement. The payment that was damages, not income. So they shouldn't have took taxes out. They shouldn't have had him pay extra taxes at the end, because the payment was a lump sum, not periodic. I mean, it's insane what they've been doing. Now, I was thinking about keeping this short, so maybe I'll do one more point. Number 266. Look up the case stating that there can never be overcompensation. And I put in Raytch with a question mark. Now, the reason that you can never have overcompensation in a tort lawsuit is that the judge takes into account what the person who is injured wants in damages, and they can say yay or nay. Then they look at the person who caused the damages, who wants to reduce their damages, and they can say yay or nay whether or not they can claw back the value of, say, the service income support insurance plan. Hypothetically, if a Canadian Forces member got hit by a car, and then they sued the driver, but they were medically released and they were getting a service income support insurance plan, and the person who had to pay the damages wanted to take that into account, they'd say, you know, if they get their long-term disability insurance under policy 901-102 and we pay them damages as well, they're going to be overcompensated. So therefore, Judge, we are asking you to allow us to take it into account to reduce how much we had to pay, because they're getting the service income support insurance plan. They're getting compensated from their injury, you know, and therefore that insurance is related to the injury. Now, if the judge has any schmick, they will say, I'm sorry, you are asking me to take into account a long-term disability insurance, which is non-indemnity and contributory and subject to the private insurance exception rule, which is also known as the Bradburn rule. So you want to say that the person's getting overcompensated, but the payment they're getting is non-indemnity, which means not compensating. So they're getting compensated from your damages that you are being ordered after I found you guilty and you had to pay the person. But they're getting their insurance through a contract which is based on a formula in the contract, and it doesn't compensate the person at all for their injury. And then if they didn't, you know, want to believe you, you'd say, well, you know, that's like the 1963, trying to remember the name of it now, but some kind of a Scottish type name. Glynn versus Scottish Union Insurance, Ontario Court of Appeal, 1963. And they said accident and sickness insurance and life insurance can never be a contract of indemnity. That's because you cannot put a value on a human life. You can't say with 100% certainty, this is how much this person is worth. So because of that, accident insurance, long-term disability, life insurance, all of those things are sold according to a contract, and you agree to pay a certain amount if the person becomes disabled. So that's the formula in a contract I keep talking about. So because you have the formula in a contract, you're not getting an indemnity, you're not getting compensated. Now, before I sign off, I'll mention what I was looking up yesterday. I'm trying to get a little bit more active on Facebook, so I was looking up remuneration. Now, remuneration is the widest possible term for income. And the definition, when I looked it up in my group, was in a Black's Law edition, Law Dictionary, edition 5, and it was talking about remuneration, you know. And first it said indemnity for loss, you know, and then it said making whole. And then it said getting paid for your time if you're employed. So you can get compensated from your employer for your time in accordance with a contract. That is also compensation, but I use that with a small c when I'm talking about that type of compensation. But if you take someone to court and you get paid damages, you're getting compensated with a capital C because you're getting a capital replacement to replace a capital loss. It's not income. You didn't have a contract with the person who hurt you. They're only paying you because they owe you a debt after having injured you. Now that's like the Pension Act. The Pension Act, and perhaps the Veterans Wellbeing Act, they also are supposed to compensate a person for their loss. In the 1997 Ontario Court of Appeal case called War Amputation of Canada, the judges said that the Pension Act has been and always has been and always will be payable to the injured military member for their loss of earnings capacity in the general labor market. So it's not for pain and suffering. It's designed to be like workers' compensation and to be a replacement for a lawsuit in tort. So you get a capital payment to replace your capital loss. It's not income. The same case talked about 3 reasons being used for the payment of the Pension Act. One was debt, what the country owed to the person injured in its service. The second one was subsistence, like being able to afford to get food, you know, welfare. And the third one was gratitude. Now, you can't put a price tag on gratitude, the same as you can't put a price tag on the value of a human life. But that was the 3 principles behind a payment of the Pension Act. But the court said that debt was the most important one. So after a person signs up, goes to war for Canada, and becomes injured, Canada owes the person a debt. Any payment the government gives that person to satisfy that is not income. It is capital. Because the person's body is capital, the payment they get for being injured is capital. Now, when I was doing a little bit of research for this, I was coming across a case about the Crown Liabilities and Proceedings Act, Section 9. It's called Sarbanes, Supreme Court of Canada, 2002. And they talked about Section 112 of the Pension Act, which said that until you get denied a pension, you can't sue the government. Okay? So if you tried to sue the government and you had a pension application outstanding, well, they'd say, we're going to put a hold on that until you get a definitive answer from Veterans Affairs Canada, and they tell you yes or no, and then we'll see about the lawsuit. Now, so there was a reference in Section 9 of the Crown Liabilities and Proceedings Act saying that if you get a pension for your injury, you can't sue the government. You're barred from suing. But the other act had a cross-reference to it, the Pension Act, Section 112. Now, I was curious about that, so I looked up Veterans Wellbeing Act, and they have a similar cross-reference. The problem with that is they're not the same. Under the Pension Act, there was no clawbacks for non-indemnity and contributory payments. Under the Veterans Wellbeing Act, there are clawbacks of non-indemnity and contributory payments, such as the Canada Pension Plan, the Canadian Forces Pension, and CISA. So they're not the same. So therefore, I think there's the right to sue under the Veterans Wellbeing Act until somebody tries it out and says, hey, you know, there's nothing barring me from suing the person who made me injured, because you're treating this as not compensation akin to tort. You're treating this like something different. So therefore, the government, the Crown Liabilities and Proceedings Act, Section 9, doesn't apply. Now, I think it'd be interesting to find out what the answer to that question is, but I don't have a pension. I don't have anything in Veterans Affairs under the Veterans Wellbeing Act. I can't test it out. I can only yabber about it. I'm going to call it quits on that point. So I want to, don't want to be too long out at night. And have a good weekend.